Quick recap on a little bit of what we talked about during the webinar this week. I talked about drug and alcohol policies and important considerations for employers when you're adopting them, revising your policies, or administering your policies. So important considerations include things like safety, efficiency of operations, and any other requirements that you might have or obligations that you may have unique to your workplace or your relationships that require certain policies or policy procedures, testing policies to be in place. For example, if you're a federal contractor or grantee, you may have obligations under the Federal Drug-Free Workplace Act. If you are subject to the U.S. DOT, or if you have employees who are subject to U.S. Department of Transportation drug and alcohol testing regulations, then you have additional obligations with respect to your policy and also a drug and alcohol testing program that you have in place. And Drug-Free Schools and Communities, or Campuses Act, also has its own regulations and requirements as well. So it's important for employers to understand what requirements might apply to them and what makes sense for their workplace. Understanding what actually is required, is there any action that must be required? Do you have to have a written policy? If so, what has to be in the policy? Does the policy need to include specific content or information? Do you have to do training? What does the training need to entail? And any other information that needs to be provided or other administration of the policy. For example, if you're an employer who has employees subject to the U.S. DOT regulations under the Federal Motor Carriers Safety Administration, the FMCSA, there's a clearinghouse that requires certain reporting obligations and checking when you're hiring individuals for those safety sensitive positions, or reporting of drug convictions under the Federal Drug-Free Workplace Act. It's important to understand and know what your policies are, what you want your policies to be for drug and alcohol testing, and including that information, or at least that reservation of rights to administer certain drug and alcohol testing under certain circumstances in your policy. And it's equally as important to keep in mind how these drug and alcohol policies may impact or being mindful of disability discrimination with respect to administration and enforcement of alcohol and drug policies. Keeping in mind that those individuals who are in recovery of substance abuse problems or addiction may be covered as a disability, or an individual with a disability under federal and state law, or employees who are taking prescription medications or other over-the-counter medications, or who may use medical marijuana may also have certain protections. So it's important to keep those things in mind and consult legal counsel if there's any concerns with respect to what your policy is, and making sure you're compliant and you're not jeopardizing or placing any liability by virtue of your policy content. Importantly, changes in New York state law with respect to marijuana back in May of 2020, the New York City law was passed that prohibits drug testing for marijuana or THC as a condition of employment. While there are several exceptions in the law and guidance, it's important to be mindful if you're an employer operating down in New York City or have employees in New York City, and you happen to or want to have drug testing. In March of 2021, New York State legalized the adult use of recreational marijuana and cannabis. And as part of that comprehensive legislation, it changed the New York labor law, section 201D, which offers protections for lawful off-duty use. So it's important to keep in mind that now, under the changes in the law in New York State, employers generally cannot prohibit lawful off-duty use of marijuana, and are prohibited from discriminating against employees because of the employee's use of cannabis outside of the workplace during non-working hours and without the employer's use or employer's equipment or property. There are certain exceptions of when employers can take action. For example, employers may take action or prohibit conduct where it would be required under federal or state law, where an employer would lose funding, or where employees manifest articulable symptoms of impairment while working that decrease or lessen the employee's performance of their tasks or duties, or that would show impairment while working that interfere with an employer's obligation to provide a safe and healthy workplace. New York State Department of Labor issued guidance back in October of 2021 that made clear that employers cannot generally test for marijuana pre-employment or random testing, because a test cannot be the basis for an employer's conclusion that the employee was impaired by cannabis. And employers can't generally test for cannabis unless they're otherwise required to do so by another federal or state law, or as otherwise permitted by the labor law. Articulable symptoms, the guidance provided some information that there's no dispositive or complete list of what types of observable indications would constitute articulable symptoms, but they must be objectively observable, and that the employees, they have to show that the employee's performance of the duties are decreased or lessened. Things like the smell of cannabis alone are not going to be sufficient to rise to that level of being articulable symptoms. So all of this to say that employers should be reviewing their drug and alcohol policies, confirm that they're compliant with whatever regulations you may be subject to, and that they are compliant with the recent changes in New York state law.